Here to present the key findings of the Respected Work Report, please welcome Commissioner Kate Jenkins.
Thank you very much, Tracy, and thank you to Comcare for hosting this event and inviting me to this very important conversation. I will start by acknowledging that I'm coming to you from the lands of the Boonwurrung people of the Kulin Nation and pay my respects to their elders past, present and emerging. I recognise the Aboriginal land is land that was never ceded. Well, it's a momentous day to be talking to hundreds of people at this forum. From my personal point of view, I have been a lawyer, an employment lawyer specialising in discrimination and sexual harassment since the start of my career 30 years ago. And as many of you will know, the laws introduced a prohibition on sexual harassment in 1984. And I acknowledge that since that time, there has been a significant amount of work being done to consider, address and try to respond to sexual harassment. In my professional life, while not all employers have taken action, I've definitely been involved with many. And certainly there was a real turning point moment in 2017 with the Harvey Weinstein allegations and that real conversation in Australia that Tracy, our host, very much contributed to in looking at the experience of workplace sexual harassment. To jump forward to 2021, and it is absolutely a watershed year as well. We know there has been significant moves since that 2017 moment, including having the remarkable Grace Tame as our Australian of the Year, having the government's response to the national inquiry that the Human Rights Commission conducted, delivered in April of this year, having the very loud and courageous voice of Brittany Higgins bring a spotlight on the experiences of our workers in Parliament, Chanel Contos looking at the workers, particularly of young women in schools. And with all of those things, we also saw a March for Justice. This is the moment, and I would like to say to you all attending that I hope that when you finish this session today, and for those of you joining tomorrow, that you will leave with a much better sense of what you can do to make a difference to help prevent sexual harassment and really bring around the turning point that we've all been looking for. Now, I will go, and I know I can see you're looking at the definition. It's not going to be a legal lecture, but I thought it was worth raising with you at the start, just reminding you of the definition of sexual harassment. As I said, sexual harassment has been unlawful since 1984, and just to put it really simply, it is basically unwelcome conduct of a sexual nature where it's reasonable the person receiving the conduct would be offended, humiliated or intimidated. It's really good to just start with that basic concept. In terms of the definition of sexual harassment, Respect at Work really reiterated that all the regulators should be using that same definition. It is the definition that's now used by Fair Work Commission. And whilst work health and safety practitioners look more at the outcome of the conduct, this is the definition of the conduct which we're discussing today. Now, there are a couple of things, and I will definitely give you a really good run through the national inquiry, the findings are happening now. But I just wanted to start off flagging with you that there are a couple of key findings in the inquiry that are important for the change that I expect we will see over the coming years. Firstly, we found that the Sex Discrimination Act had not been able to do its work as well as we would have hoped, notwithstanding that sexual harassment has been unlawful for more than 30 years. At the same time, we found that employers, not all, but many, had been taking actions and they were not right actions to be preventing sexual harassment, and they were generally focused around what you do after it's happened. We also made a finding that the work health and safety laws didn't require reform for recognising sexual harassment was covered. Indeed, those laws already created a duty on employers to prevent risks to health and safety, and we made very clear what that risk is caused by sexual harassment. Now, the reason I start with that just opening comment before I take you through the content is that I recognise and welcome that the attendees at this session include work health and safety practitioners, human resources practitioners, managers, and also some lawyers. You, in our national inquiry, were people that we described as having a specialist interest or expertise or a need to have more detailed knowledge about sexual harassment to enable you to deal with this properly. But the one thing I want to remind you is this isn't a move of sexual harassment from the Sex Discrimination Act into the Work Health and Safety Act. This is a really complex issue that's driven by gender inequality, power disparities, lack of accountability, lack of transparency. And it is very complex, but this is not a land grab for safety to take this out of the hands of the HR people. It's not for you to say you didn't know what you were doing. We do prevention better than you. It is absolutely an opportunity for different parts of an organisation to draw on the expertise in all those parts, because together that is where the answer lays. And in particular, it's why we recommended the work health and safety, as well as Fair Work, as well as the Human Rights Commissions, all conduct or engage in more education, as we recommended sessions like this be held so specialists can understand the nature, impacts and effects and drivers of sexual harassment to enable you to be part of the solution. So if I can go to the next slide to just give you a quick run around the progress to date, I guess, of the Respect at Work National Inquiry. So as I've already mentioned, in 2017, not just Australia, the globe started having a much more detailed conversation about the experience of sexual harassment at work. And that came to Australia. It was around dinner tables, and some of you will remember, and it's perfectly appropriate that particularly Tracy Spicer did call out in the media and entertainment industry here, were there people who had experienced sexual harassment here? Now, you will know there has been a rolling number of industries since then that have spotlighted the issue of sexual harassment as each different experience becomes public, but also as industries start to take leadership. So the inquiry used the particular powers of the Australian Human Rights Commission. It was an 18-month process. It coincided with our national survey on sexual harassment. So we surveyed 10,000 people. We conducted 60 public consultations with more than 600 people, 460 written submissions, many of which are still available on our website. Economic modelling was conducted. We looked at the experiences globally, and the report was launched with the Honourable Marise Payne, the Minister for Women, on the 6th of March 2020, which was a Friday, and some of you might recall it was pretty much the start of COVID really taking ground in Australia. Jumping a little bit further, I've already mentioned there are a number of issues, including in the High Court, at AMP, in the University of Adelaide, and as I've mentioned this year in our Federal Parliament House, that have put the spotlight on sexual harassment. The government responded to the report and its 55 recommendations on the 8th of April this year, led by the Attorney General, Michaelia Cash. And since that time, there has been a significant amount of activity to implement all of the recommendations, which were accepted in whole, in part, in principle, or noted. And as the chair of the Respected Work Council, I can assure you that in the just over 6 months, I guess 7 months since that time, there has been a significant amount of work, including from Comcare, Safe Work Australia, the Human Rights Commission and others. Next slide, please. So just to give you sort of a whirlwind, I think some of you will know the reports behind me. It is a significant report. However, I know that there are lots of different resources being now made available to make it very accessible and useful. And if you leave this session and you haven't looked at it, I would encourage you to read the community guide, which gives an overview of the report, 20-page executive summary, which while that most of it might not affect your specific day-to-day work, it absolutely gives you the picture of how those 55 recommendations all intersect to make the difference. So the findings of the inquiry were that sexual harassment is a common experience. It found that 1 in 3 Australian workers had experienced sexual harassment in the last 5 years, and that was up from 1 in 5 in 2012. In particular, it found that there were certain groups of people who experienced a higher risk of sexual harassment, and in particular, those were LGBTI communities, people with disabilities, Aboriginal and Torres Strait Islander people, and migrant workers. We also observed that it was quite difficult, although we didn't have the specific data on this, but for people working in regional, rural and remote areas. So we do know that those people, some of those groups experience at the rate of 1 in 2 workers in the last 5 years. We found that sexual harassment happens in all workplaces. So one of the important things that we got to do on this survey was to break it down into the 21 large ABS industry sectors for the first time. And just for you to know, the next survey, which is funded by government and one of the recommendations of the report, will be conducted by the Human Rights Commission next year. So it will be very interesting to see what the statistics tell us at that point in time. The finding was that there wasn't, if you've got an average of 1 in 3, there's not a perfect workplace. But as the start of the Me Too sexual harassment conversation told us, the top experience of sexual harassment was information, media and technology at 81%, and also arts and recreation at approximately 50 or 49%. Other industries that were notable were male-dominated industries like construction and mining, but there was a significant and really useful data set there in understanding in more detail how industries work. And I flagged that for you because that is something in terms of how safety regulation has worked. It has recognised the systemic nature of issues and injuries, and our finding really was the best way to look at that was by industry, to understand, for example, in the media and entertainment industry, it was still characterised by mostly men at the senior levels, by temporary and insecure work arrangements that relied on word of mouth referrals, some high competition to get into that industry, a whole range of other things. Similarly, when you look at, depending on what industry you're in, you can get the data, but you can also think about if you're in retail and hospitality, young workers that are facing customers and clients and a whole range of other factors at play. We found that the current system relied on the victims complaining. It basically was a system where the laws made the conduct unlawful, but under the Sex Discrimination Act, the only way the act was really enlivened was if a victim would get the courage to complain. And yet we know, and this has been true over the entire time of the Commission surveys, and we've held 4 of them over about 20 years, that complaint rates have hovered around 17% for that whole time. Australia's, as a lot are not a group that want to complain, but also we found that the people who do complain do experience negative consequences as a result. And in many cases, there was no change as a result of their complaints. So a system that relies on complaints is not actually getting to the problem, and it's not preventing the problem. And finally, we found that sexual harassment has a high cost. For the first time, again, Deloitte Access Economics was engaged by Treasury to conduct an economic analysis of the cost of workplace sexual harassment. Now, at that point, we did not gather all the data that would tell you the long-term cost, but based on the information that was available about the immediate impact of sexual harassment, they estimated that sexual harassment costs the economy $3.8 billion, and the majority of that is borne by employers. Next slide, please. So as I've said, we made recommendations, 55 recommendations in 5 different areas. In particular, we found in terms of drivers that the main driver of sexual harassment is power disparity. It is not driven by sex, as some people like to paint. Power disparity, and the main power disparity in many workplaces is still gender inequality. But other groups, as I've told you in the stats, also experience intersectional discrimination. And we heard of a lack of accountability over time, that over time the system and employers have worked hard to resolve issues but also keep them confidential. A lack of transparency has resulted in what seems to be, for some people, almost a daily experience of sexual harassment, and for others who are repeat offenders. So broadly, the areas were data and research. I've already mentioned our survey, and there is other really terrific research things that happen across Australia in terms of gender equality. The Anne Rose conducts a national community attitude survey that provides really valuable data on our actual attitudes. So 1/4 of people think that women find it flattering to be persistently asked out on dates, even where they've consistently refused them, for example, and a great mistrust of people who bring complaints. The second area was primary prevention. So that involved looking at education, media, and public campaigns. The idea, and small business particularly said this, that the sort of campaigns that government runs and, what's on the bus stop sends a message, what happens in the media, what's written about, how it's written about makes a difference, and what children are exposed to even from a very young age at school. And speaking of young people, it was pretty alarming in those statistics to discover that 1 in 5 workers who are aged between 15 and 17 have been sexually harassed in the last 5 years. That is a cohort that haven't been in the workplace for the last 5 years, but they're particularly vulnerable. And so education in schools, as we've got the current conversation about consent education in schools, that's important. Education about gender roles and education about workplace rights. The third areas, and I'll go through the next 3 areas with some slides for you to give you a bit more detail. So we did come up with recommendations about the legal and regulatory framework, the workplace prevention and response model, what is good practice, what should work as opposed to what's been happening, and about support, advice and advocacy. So can I go to the next slide, which is about the workplace prevention and response framework. So one of the things in this is chapter 6. So to employers, I will often say, if you're in the workplace, the 2 chapters that are probably most useful for you is chapter 3, which describes how sexual harassment works and really helps you understand the systemic nature and how different industries experience sexual harassment in different ways. And chapter 6, which describes what a new framework or the new response will look like. And I guess just reminding, many of you will know, traditionally using the Sex Discrimination Act, and the reasonable steps defence, employers have taken a view that what I've got to be able to do is I've got to prove if sexual harassment comes in, to defend ourselves, I've got to prove that I did some things that means it's not my fault. So traditionally what we have, and I would have advised you in my practice time, is you had a policy, you did training that was usually mandatory, and you had a complaints procedure. What we realised is that a system hasn't worked. If we start at the end, people, notwithstanding how genuinely good your complaints procedure is, there are very good multiple reasons why people do not want to bring a complaint forward. In small workplaces particularly, if you need to keep your job, then bringing a complaint forward can work against you. And having a policy and running training, we now have evidence that shows doesn't automatically turn people into compliant people. It doesn't assure you that they understand what sexual harassment is, but without accountability, it also doesn't really have any huge impact. And I've been known to say in the past that, you know, as a lawyer over time, I've drafted the policy for companies, I've helped draft and deliver the training for policies, I've written the memo that goes out before the Christmas party, and then I've done the case that came in after the Christmas party. So, and that was, it used to be sort of, you know, that if you want to think, and it's not that Christmas party guarantees sexual harassment, but as an employer, you could notice that there are particular moments and particular situations where there seems to be more high risk conduct. So I will talk you through this domains, but I guess I'll say before I do, there are a couple of particular recommendations that weren't specifically for government, they were for workplaces, they were for employers. One was that we recommended that the best way to address sexual harassment, or the most effective way that seemed to be getting traction, was through industry action. And there's a few good reasons for that. One is those common drivers. Two is if you come together, it's much more efficient and effective to all sort of pool your resources and come up with one great training initiative. Three is a lot of people in a lot of sectors move between. So if I go back to that media and entertainment sector, if you're a camera operator and you work on this season of that show and then you move to another, you are constantly moving between different employers, but in the same industry. So we did encourage industry action to use that knowledge. It also gave a bit of cover that in practice, a lot of employers don't want their name associated with sexual harassment, but it's been really encouraging to see, for example, the legal sector has really moved on industry action, and the Minerals Council of Australia has led an industry initiative as well. The other thing that we really recommended was in thinking about how you would move to prevention, and recognising that safety laws already apply, that there were some fantastic lessons in this way that organisations address safety issues that can be used in practice on sexual harassment. And there are a couple of companies that I worked with over the course of the inquiry to sort of say, and one of them was BHP. I went in and I said, now you're all very focused on safety. If you were to put safety through that lens, how would it work? And they and others have found that as they're looking at other psychosocial potential injuries like bullying as well as sexual harassment, that actually there is some really good, it's a way to realise, and you'll see in the report, there's a bit of a bow tie structure, which you'll know more about than I will, but that idea, if you look at the event and you went on both sides, what was done to prevent it and what was done in response. And what they said to me was, when we did that, we realised most of it's on the response side. We're not doing a lot on identifying what the issues are and preventing. So these domains, as I've written out, are about, it's always about leadership and really particularly the top leadership, but also the line leadership. People constantly told us that a safe and respectful workplace was one that had a line leader that role modelled the right behaviour and they felt safe to raise their issues. The second domain, risk assessment and transparency, is really drawing on the safety model of doing work. So really using all of those obligations in the work health and safety laws to identify systems of work and people who are at risk and look at mitigation. Third area was culture, so broader culture and those organisations that had gender equality, but also a psychologically safe workplace was super important. The fourth area in the prevention side was what I've described as knowledge. So you will see in our report, and you will know from the work that Comcare is now doing, is that Comcare has done some bite-sized things and some bigger modules, and there's micro-learns. I'm learning all these things. The reality is the knowledge needs to come in repeat useful ways. It's not a once every 2 years sheep dip exercise. It needs to come in multiple ways and regularly. The next area is support, looking at the supports available, and I'll come back to that. Reporting, so multiple options for reporting, including anonymous reporting. And finally, measurement. So really tracking what do you know, what's happened, and what's worked and what hasn't worked, and sharing that information, which takes us back to transparency. Could you go to the next slide, please? And you will know for some of that, in terms of the risk assessment in particular, Safe Work Australia produced some great guidance material in January, and we and the Fair Work Commission were consulted in relation to that. And also there has been, we are producing some great education materials, Comcare and also Fair Work Commission, so which will all be another one of the recommendations, again, that's been supported by government, is to establish one platform to share resources that will make that available to you. We are currently putting that together. It will be available next year, but come to each of the agencies in the meantime. So the next thing I just wanted to mention is I did consider, you know, do we throw it all out? Do we start again? Do we write a new Sexual Harassment Act? But the conclusion that we drew in the inquiry was that Australia has strong workplace laws, and it is the intersection of these three laws working together that should deliver us better, safer and more respectful workplaces, and therefore actually more productive workplaces. So sexual harassment was specifically prohibited in state, territory and federal legislation under the Sex Discrimination Act, and that has been the case for a long time. Our recommendation, we made some recommendations about modifying the laws, and some of those have been passed, and the balance are to be considered by government in December through to March. So I encourage you to get involved with that consultation. They have included aligning the definitions of work to match work health and safety, so more like the PCBU concept, because we found that the definition of employer-employee wasn't really fit for purpose in how work is done now. And as you will know, we've also recommended a positive duty be included in that act, that act really now only relies on victims complaining, and that's not been an effective system. We found that the work health and safety laws did apply. Safe Work has got straight onto it, produced guidance, and we recommended the Boland Review recommendations about psychosocial health be implemented, and I understand that's on track. And last was the Fair Work Act. So whilst that does not explicitly prohibit sexual harassment, a lot of workers said that was the place that they looked to for information and to learn about their workplace rights. So the government has already introduced a stop sexual harassment order. It's not called that. It's actually using the stop bullying jurisdiction, and that starts today. Actually, it was passed on the 11th of September, and it starts today. And so Fair Work has been really updating their materials as well. So there's lots of activity. The other thing that's worth mentioning about those three lots of regulators is that part of the new system is to bring together the key regulators so that we can work together in a more consistent, clear and easy to use way for workers and employers. So the Respect at Work Council was convened and supported by government. We had our first meeting in March, and we are having our last one for the year next week. If you're interested in the work of the council, it has a website on the Attorney General's website. If you just put in Respect at Work Council, you should find us and learn about what we're doing. You can register if you want to keep up to date with what we're up to. And it's made up of regulators like the Fair Work Commission and Comcare and the collective of, and you're going to know it's Hauser and Hauker, the compensation and the work health and safety bodies across working together with associate members from employer, employee and community sector. So it's been a really effective group working together, and we are speaking absolutely regularly, weekly for some of us, which has made a huge difference. And the final slide, which I'll just show you because I just want to remind you that one of the things we found in Respect at Work was that this experience of sexual harassment could be really harmful, but also the experience of raising a complaint, processing a workers' comp claim, even getting help could also be really harmful. And so one of the things that I have, particularly in my work with Comcare and the work health and safety jurisdictions, is to say that, you know, this is why there's a focus on person-centered responses, is that the last thing that safety regulators want to do accidentally by going through a very complicated investigation process is cause more trauma and harm compounded on a bad experience at work. So we did make some recommendations about how people could better access information about their rights, but also the supports they needed, because we found that often the only way you could get the supports is if you went and made a complaint. And those things should not be linked. It should be up to the person on how and what they want to do. So that is that's the kind of whirlwind around 18 months and 900 pages. I hope that was useful for you. I'm very excited for you on the range of speakers you've got over this conference, and I'm very happy, Tracy, to take questions if anyone has any questions to raise.
Thank you so much, Commissioner Kate Jenkins, for your powerful work. We do have some questions that have come through, and the first one is, how do we balance as a workplace taking action when we're made aware of a risk, when we've been asked by the victim not to take action, that they want to let someone know and have it on the record, but they don't want to take action?
It's a great question, and probably almost the first question that is asked actually for years. So the first thing I would say is that what we know is if a person comes in and says, I've got a complaint, but I don't want you to do anything. I've answered this for many years. They do want you to do something. They just don't want to have to pay the price for it. So the first thing I would say is, for many organisations, I would recommend you look at your complaint processes and then do a sort of a review. And I would encourage you to find a trauma expert. That is often not something that employers, corporates have really had, like Rape and Domestic Violence Services or one of the CASAs or Blue Note. These organisations that are used to dealing with gendered harms and trauma, and ask them to look at your processes and consider how much in that process, because historically what everyone's focused on is, one, getting the bad guy. So, and I say guy, it's not always men, but many times it is. So the discipline side, or second, the idea that, well, if there's someone in this that's causing a risk, I've got to stop that from a safety side. But you've also got an obligation for the welfare of the person who's raised the complaint. So the things, it's never straightforward, but the things that I would say is, first and foremost, make sure your processes are trauma-informed and victim-centric or people-centered. Work with that person, take seriously their desire, their fears, and it may be that they don't want a complaint, but that might are the things you can do to make the workplace safe. So I would say that would be the first option. There are some situations, either when there's immediate danger or when the allegations are so serious that you might need to take more action. But you know what? A lot of sexual harassment issues are, you know, what I would call almost daily sexual harassment that wouldn't end in anyone's termination of employment, but is unlawful and unacceptable. So then I would say in most cases when people ask about a particular incident, usually with that, my next question is, what are you now going to do to make sure that you have a better sense across the board of what's going on? How have you considered, you know, even if that issue is raised, you can see trends and themes. Anonymous reporting is really valuable. So it's not a straight down the line, but I know that people, because historically we haven't acted until someone comes forward, the first question is always this question, and it has been for a long time. What do I do when that person looks me in the eye and says, this has happened to me, but I don't want you to do anything? I totally understand that. Organisations that have started taking action, you get a lot less of that. You get much more confidence that the system will work.
Really good advice, thank you. The next question, how many sexual harassment complaints were false or vexatious? And was this aspect included in the survey?
Yes, so this sense that sexual harassment cases are made or complaints are made vexatiously does seem to be a community attitude that we need to shake. The reality is there are very few vexatious sexual harassment complaints, and a good process with natural justice should surface what those concerns are. The other thing I would say is that in terms of those stats, actually the majority of sexual harassment no one's complaining to you about. So only 17% of people raise a complaint. That's either formally or within the organisation. So rather than being worried about vexatious complaints, I'd really encourage employers, again, I come back to anonymous reporting mechanisms and also safe anonymous surveys that will tell you more accurately what's going on. That is the most valuable thing for you to have coming forward. The reality is most of the people we spoke through the National Inquiry hadn't raised complaints, or they had and it had not been addressed properly. But as a practitioner, I would say you'll have all the usual mechanisms in place, but the evidence shows there's very low reporting, vexatious reporting. So I wouldn't be it seems to get a lot of attention, but it's definitely not the issue.
Certainly. Next one, I'd be interested to hear your thoughts about how ancillary/accessional liability will operate down a supply chain.
So it's really interesting thinking. So that's a really technical, good question asked. But in practice, responsibilities, the change is to really recognise, and I'm not the best expert on work health and safety, but many of you are, that looking at the duties, it is now about sexual harassment at work, and the coverage of responsibility is more than just the person's direct employer. So if you have contractors, and that was something that really came up strongly at the National Inquiry, that people don't work in just the traditional way, 9 to 5 with one employer, and you're only interacting with people who are employed by the same employer. So if I give you the legal answer, the Sex Discrimination Act makes a person individually liable for their conduct, makes the employer liable for unlawful sexual harassment, and does make there is liability for people who aid and abet the sexual harassment, so who might be present, and particularly managers who might not act. But I guess focusing on that, the reality is if you're in a workplace and you're working with someone, there is probably some responsibility. And from a work health and safety point of view, there is that clear network about responsibility for your operation or the operation of your business.
Okay, this next question is probably more opinion-based than legal, Kate. Monica has asked, I'm interested to understand views on the Workplace Gender Equality Agency's employer of choice process.
Yes, you can imagine, Tracy, I have views on lots of things. So it's a good question. And for those of you who are interested, the Workplace Gender Equality Act is currently being reviewed as part of its regular cycle. So I'd encourage you, if you want to make a contribution, I would give a plug for them. I think it's really useful. My view is a lot of the really, when you look at that domain where it said risk assessment and transparency. So the Workplace Gender Equality Agency is a pretty innovative and world-leading initiative that we have that really basically converts the concept of behavioural insights of not necessarily punishing everyone, but asking for people to report on the key measures that we know are the measures that move towards positive gender equality, and to make them public. And the reality is, even without a punishment, that initiative, that act of collecting the data, surfacing it, making people look at it, and then also being held externally accountable for it, is proven to improve practice in organisations. So as a general comment, I would say hugely valuable data set. The exercise of reporting to them, even though some of you will be the people who fill out those forms and you might not love them, but the exercise of both reporting and having your board look at those things is very important. And employer of choice just adds in terms of that, showing that organisations are taking action. So it's the carrot part of the carrot and the stick. Our stick hasn't been as effective because people are reluctant to complain, but the system, and these are all interconnected, so the Workplace Gender Equality Agency is on the council as well, that's the proactive and positive part.
Commissioner Kate Jenkins, thank you so much for your tireless work in this area in recent years, and we really appreciate you taking the time to share your insights with us today. Thank you.
Thank you, Tracy, and I wish everyone a great day.